Hello people, this is Avnish Tiwari, faculty St. Peter's Law Academy. I welcome all of you again in this series what we are doing on judgment writing. So to start with, I must be having a recap of previous two parts of this series, because today we are going to have the next part, that is the third part of this series on judgment writing. So in the previous two parts, if you remember, right now I am presuming that you all are watching our videos. So in the previous two parts of this series, we have discussed the introductory part of judgment writing. So I must bring those things briefly again, so that you will be having the connect between the previous two parts and the part what we are doing in this video. So if you remember, I had given you different aspects of judgment writing, and aspects means those things which are going to be inculcated, those things which are going to be written by the judge in the judgment. So for the first thing, what the court should refer in the judgment is the facts in brief. After that, the evidence, and after having the evidence in the court of law, the judge will mention the sequencing, and that is called marshalling. And after sequencing all those evidences, the next thing is that which is called as appreciation. So marshalling and appreciation, these two things are very conceptual, and we need to have a pause and to understand those things before moving to the next level. I'll bring that. And after that, the judge will record his or her findings, and those findings will be formulated. Means these were the various stages. Means these stages will be written in the judgment, and these points were the common points. And I told you that after this we are going to bifurcate, we are going to separate judgment writing in civil cases from the judgment writing in criminal cases. So today I will start by this heading, judgment writing in civil cases. And before going into the depth of this part, I want to bring your notice to the concept of marshalling and appreciation of evidence. Marshalling, because writing the facts in brief is not a tough task, but what is marshalling and what is appreciation of evidence, these two things are something which need to be understood, particularly by aspirants, because when it comes to understand the judgment from the point of view of aspirants, they are going to be judges, and if they are able to understand the art of writing the judgment before becoming the judge, of course after becoming the judge they are going to produce a very high quality of judgment. So we are trying to learn things from the perspective of an aspirant who is going to be a judge. So I was saying that we should focus to understand this word called marshalling. So literally speaking, marshalling means sequencing. It is a kind of logical sequencing of evidence or any fact or facts. Logical sequencing of something, maybe evidence, maybe facts, but literally speaking, marshalling means logical sequencing or logical assemblance, to assemble certain facts, to assemble certain evidences in a particular and logical manner, or we can call it logical assembly or assemblance. Logical assemblance. Assemblance means to combine certain facts together in the right perspective, in a logical manner, in a logical sequence. Means once the evidences are produced in the court of law, it is the duty of the court to arrange those evidences in the right perspective, in the logical manner. This is called marshalling. And after doing this marshalling, now the time has come for the judge to analyze those evidences which were actually marshaled by the judge himself. And the next step is appreciation. Appreciation. Appreciation means evaluation. Evaluation of evidence. So evidences were produced and the judge arranged all those evidences in the right sequence, and now the judge is going to analyze those evidences. Judge is going to apply his or her mind on those evidences, means what is the relevancy of a particular evidence? Is that evidence admissible or not under the law of evidence? So these questions will be answered by the judge in his mind, and when he is doing such activity, it is called he is appreciating the evidence. Right. So this is called appreciation. And once the evidence is appreciated, what will be the next thing a judge is supposed to do? And through this evaluation, through this appreciation of evidence, the judge is going through the analysis of the merits of a particular case. Means what are the facts which are in issue, what are the relevant facts, etc. So all these things will be decided by the application of law of evidence by the judge in that particular case, because we know that the Indian Evidence Act is applicable in the civil laws as well as in criminal laws. So whichever part of that Indian Evidence Act is applicable in whatever case, it is the duty of the judge to bring that part of the Indian Evidence Act for the application. And these two things, like marshalling means the arrangement and the appreciation means the evaluation, are sometimes mingled with each other. Means it is hard to completely separate one from the other. Means they are being done together. Means there is a kind of overlapping between these two things, marshalling and appreciation. Means there is a possibility that a judge is going to find the art of arrangement and the art of appreciation which is inseparable from each other. Means overlapping. Sometimes overlapping of marshalling and appreciation may be there. Generally, the judge will find that marshalling is completely a separate exercise and appreciation is entirely different. But sometimes the judge may find this also, that there is a kind of overlapping between these two concepts, these two ideas. So what is the exact thing what the judge is going to do when he is doing the act of marshalling? Theoretically, we said that the judge will arrange the evidence in a logical sequence. But what is the exact activity the judge is going to do when he is going to marshal the evidence? I will tell you this dimension in an elaborate way. Means what is the next thing the judge is going to do? So while marshalling, I'll write it, while marshalling, the judge is required to do following things. While marshalling, the judge is required to do following things. Following things. So what are those things? The first thing is, number one, to study. To study what? We know that by this stage evidences have been produced in the court by the parties, and now the judge is marshalling, means without studying those evidences, without knowing the content of the examination in chief, the cross examination and the re-examination, the judge will not be able to marshal, to arrange the evidences produced by both the parties. It means that you must be having some idea about examination in chief, cross examination and re-examination with the help of Indian Evidence Act. And to have the peripheral idea about what is examination in chief, I must tell you that if one party to this civil proceeding is calling his own witness, then if the same party is asking questions to his own witness, the testimony, the statement made by that witness is something called, means this whole process in which the question is being asked by a party to his own witness is called the examination in chief. And if one witness is being examined by the opposite party, it is called cross examination. And if after cross examination, again, if the same party is again asking the question to his own witness, it is called re-examination. So these three concepts can be understood with the help of Indian Evidence Act. You can read those provisions under the Indian Evidence Act. So I'm not going to bring those things right now, because we are moving with the idea of judgment writing. So the judge is doing marshalling, and in marshalling it is very important for the judge to know about evidences. And how will he come to know about the evidences? Of course, the judge is present and the examination in chief is going on, cross examination is going on, and again the re-examination is going on. So through this procedure, the judge will develop his own idea as in what evidences are being produced, what testimony is being given by the witness, etc. And means the judge is observing these proceedings in the court, and after observing these proceedings, the judge is called that he is studying the evidence or the fact. Means when the judge is doing the marshalling, he will study the evidence, he will study different facts. And what is the next thing? He has studied it, and once he is studying those evidences, those facts which are coming up from those procedures like chief, cross and re-examination, what is the next thing he is going to do? He is going to sort out. He has studied all the evidences, and now the time has come, like he will pick up, he is going to sort out as in what evidence should be taken from this whole process, and only those evidences will be picked by him which are found to be relevant and admissible. If some evidences are there which are completely irrelevant or not admissible, so the court will reject those evidences. So now the time has come, after studying those evidences or facts, the court is going to sort out. To sort out evidences or facts. So, the judge studied those evidences or facts, and now the judge is going to sort out, means to pick up, as in what evidence should be taken and what evidence should be rejected. And after that, once the facts are sorted out, what should be the next stage? Suppose one witness was examined in chief by the party, means the witness will make his own statements. He will give his own testimony in the court of law. And once he is making his testimony in the examination in chief, it is possible that when he will be examined by the opposite party in the cross examination, he will change his statement. So, it is possible that a witness made some statement in the examination in chief, but he made some variations. He changed his statement when he was cross examined by the opposite party. So, the statements made in the cross examination will also be studied by the judge, and now if any variation or change is going to be made by the same witness when he is cross examined by the opposite party, this variation or the change will also be picked up by the judge. Because if the testimony of the witness is going to be accepted by the court, of course, it will help the party to prove his case. And if his statement was found to be in variation, means he has changed his statement, it means the party who called that witness, his case will be weakened. It means this change of behavior, this change of statement is also very, very important thing, which may come from the cross examination. So, whether the witness is remaining static, whether he is not changing his statement or he is going to change the statement, all these things will be observed and considered by the judge. Means, what is it? Once the evidences are sorted out through examination in chief, cross examination and re-examination, the judge will make a point regarding these findings also. And now the judge is having the basic idea, as in what evidences were produced, by which party, what was the quality of the evidence, whether this particular evidence should be accepted or rejected. And now he has a concrete idea about the evidence or the facts available on the table in the court. And now it is very easy to arrange those things, means the filtered facts and evidences are available at this stage before the judge. And now if something very important and concrete is available on the table, it is very easy for the judge to arrange those things, right? So, he will arrange. So, the act of arrangement becomes very easy at this point of time, right? Means the actual act to arrange those evidences and facts will be done at this stage. Actual arrangement. So, this is marshalling, means it is not so simple that a judge will come in the court and he will arrange all those evidences. No, it will take some time for him to have this activity in the court of law. So, if you remember those stages in a judgment: facts, evidence, marshalling, appreciation, application of law, findings, judgment. So, facts, the first step is not that difficult to write. To observe and study the evidence is also not so difficult, but marshalling is a bit conceptual, and we have learnt it how the marshalling is done. And once the marshalling is complete, now the time has come when the judge is going to evaluate those evidences which were actually arranged by the judge. Once the marshalling is done, once the sequencing is done, the time has come to evaluate evaluation. So, I told you that evaluation means to weigh the value of the evidence, to weigh the quality of evidence. This is an art, right? So, this weighing or the evaluation or going through the nature and the quality of evidence is called evaluation of the evidence or appreciation of the evidence. So, when the judge is arranging those evidences and facts, this evaluation may be done parallel to that sequencing. Generally, marshalling and appreciation are two different activities, but in practical you will realize that when the marshalling is being done by the judge, his mind is working on the evaluation of those evidences also. So, these two concepts sometimes are separate and sometimes merged with each other. So, if you are going to write the theory of writing the judgment, you can mention these two things separately, and you can make it a point that sometimes marshalling as well as appreciation may overlap with each other. So, this marshalling and appreciation is over. Now, what law will be applicable? That will be decided by the judge. So, what law is going to be applied in that particular case or in that particular circumstance, that will be decided by the judge. Means the application of law is the next point. And after that comes the findings. Means the process is going to culminate in the findings of the judgment, the judge. Means what are the findings of the judge? Once we look at the civil proceeding, you find that when a suit is filed and that suit is being tried, what are the different things which are happening in the court? We know with the help of CPC that a suit is instituted with the help of presentation of a plaint, and for that you can refer to section 26 and order 4 of the CPC. And once the suit is instituted, summons will be served on the defendant, and once the written statement is filed by the defendant, the court will settle those issues which are going to be answered by the judge. Means issues are framed under order 14 of the CPC. So, how the issues are framed and who frames the issue or issues? It is the duty of the judge, and those issues will be answered by the judge himself. Means if those issues are answered, it is called the findings. Means the court has found something out of this whole procedure. So, the findings will be recorded by the judge, and now those findings will be formulated by the judge, and that formulation is known as judgment. Although we have the definition of judgment under section 2(9) of the CPC, but that is very theoretical, but in practice the judgment is something more than that. So, now the time has come to draw up the judgment on the basis of those findings. Means those findings will be mentioned in the judgment. Judgment is a kind of formal expression. Means some formalities will be done. Although we do not have the straitjacket formula to write a judgment, we do not have a fixed pattern of writing a judgment. One judge will write a judgment which is entirely different from the judgment given by the other judge, may be in a similar situation. So, why these differences are happening? Because we do not have a fixed formula. It completely depends on the legal acumen, the legal attainment, the legal knowledge of the judge. Although we know what are the contents, what are the things to be written inside a judgment, and what are the contents, what are the things which are supposed to be mentioned in a judgment, you can understand with the help of order 20 of the CPC. Contents of a judgment with the help of order 20 of the CPC. Order 20 of the CPC. There are different rules under that order. I am not going to refer to those rules right now, but please refer to this order number 20 of the CPC and you will come to know as in what are the things which are supposed to be written in the judgment. Means after going through all the stages, now the time has come that the judge is going to pronounce the judgment in the open court, and we have section 33 of the CPC which also talks about judgment and decree. So, you have to refer to section 2(9) of the CPC plus section 2(2) of the CPC, section 33 of the CPC and order number 20 of the CPC to have the basic idea. Means once we are learning as in how to write the judgment, at the same time, means parallel to this learning, we must be having some theoretical knowledge and some idea about what provisions are going to help us in understanding the judgment writing in a better way. So, do not forget to refer to those provisions what I am mentioning right now, because these provisions will be used at the later stage of the judgment writing again. So, please try to enhance the level of your understanding with the help of referring to those provisions under different statutes. Are you getting the point? So, what is a judgment? This is the question at this point of time, but we know what is a judgment. I am not going to teach you what is a judgment, because that is a part of the CPC, but we have arrived at a stage where the judge is going to write the judgment, and we know the contents to be presented or written in the judgment with the help of order 20 of the CPC. So, beyond this, I will give some examples, some situations, and I will write a judgment in this series itself. So, the next part will be dedicated to a practical explanation and analysis of a given situation, and the presentation means the demonstration of writing the judgment live. So, I will write the judgment live in the next part. Thank you so much for being with me. Please stay tuned with us and do watch our videos, and do not forget to like, subscribe and comment on our YouTube channel. Your comments are really valuable to us. Please do watch our videos. Thank you so much.